this is going to be a sort of a hosted jointly by Mike and myself. As I mentioned, Mike is a I didn't mention this. Mike is a U.S. patent attorney. Came to us and set up our U.S. practice. We'll actually launch that beginning of 2013, and like our Israel practice, we serve, of course, Israeli clients, but also clients and the clients of associates from around the world. Okay, now if I can get this to move. Okay, so the first thing is, once I stop talking initially, Mike is going to present duty of disclosure of the USPTO. For most people, I imagine it'll simply be a revision, a review of what you already know. The next part of this will be my presenting what you need to do in the Israel Patent Office, with the assumption that you've already pretty much taken care of things, or you are taking care of things in the US. And I will clearly, that will be explained when I get to it. And finally, to disclose or not to disclose, that is a question which relates specifically to the US and specifically to non-material references. And again, Mike will explain that, and that will be pretty much dessert. So those are all the questions. So here's really the question. Israel and the US are very strange. They have two main things in common, I would say, which sort of set them apart. One thing is you normally do not request examination. You can accelerate examination, but in the normal run of things, examination begins when it begins, when the specific examiner gets to it. That's one thing. And the other thing is that each of us have an ongoing duty of disclosure. But having said that, there are differences. The question is, when does that duty start? When does it finish? At what juncture, once we know about something, when do we need to file those disclosure documents? And finally, what documentation is actually required? So there are variations. Both the US and Israel have slightly different answers to both of these things. And what I hope we will do today is to get an understanding of what those differences are. And even if you have no Israel applications and you just want to know about the US, okay, or whether you actually have Israel applications, but you're filing maybe those with us, but your US application you're filing with someone else, you will still gain a lot of knowledge, I hope, from what we're about to discuss. Okay, and with that, Mike, I'm handing it over to you.
All right, thanks, Jeremy. So thanks everyone for joining us today, whether it's morning or afternoon or evening. We really appreciate you spending a little bit of time with us. I'm going to be giving a review. I think many of you probably know some of this about the duty of disclosure at the USPTO, and I think about the topic as being equal parts boring and terror. And partially it's because, well, it's kind of involved, it's kind of administrative and very bureaucratic. But at the same time, as time goes on, as we'll see in a US patent application, things get more difficult in terms of being able to satisfy the duty of disclosure. And then also at the end of the day, if you don't do it sufficiently, or somebody doesn't think you did it sufficiently, it can actually lead to some pretty bad consequences. So we're juggling these things that we're trying not to fall asleep while doing it, but realizing that if we don't do it properly, it could be a real nightmare. So there's our equal parts of boredom and terror. Next slide, please. All right, so the disclosure requirement at the USPTO has this origin in the federal regulations, which says that there's a duty of candor before the US when getting a US patent. And basically what you're talking about is, well, the US government doesn't want you to hide anything. and you have to behave properly towards the US government if you're trying to gain a property right. So this duty to be honest and to be forthright to the USPTO, it applies to every single person connected to a US patent application, whether it's the inventor or the CEO of the company, the in-house people, or any of the patent attorneys, whether they're associates in their home countries or the US representatives. So it's a really broad obligation. But so what's this duty? The duty is to disclose to the USPTO anything that you know about the technology or that's material to patentability. But those are pretty loaded things, which we'll talk about in the next slide or two. And how do you satisfy it? You satisfy it through this mechanism, this bureaucratic mechanism of the information disclosure statement. Next slide, please. Okay, so we said that anything that's material to patentability has to be disclosed. So what is that? Anything. There's the run-of-the-mill stuff like patents and patent publications, other published literature. But if there's a website which might be material, that has information that might be material, that needs to be disclosed. If there's a doctoral dissertation somewhere in a library, that needs to be disclosed. Any material which is public. There's a really famous question on the US patent bar, and they used to ask it every year, which was, if there's a dissertation that's written in Polish and is only found in the library in the University of Warsaw, but it's publicly available and cataloged, does that need to be disclosed on an IDS? And the answer, of course, is yes. As long as it's publicly available and could be material to patentability, it needs to be disclosed. At the same time, the material that you have to present to the USPTO, it doesn't have to be duplicative. So in the federal rules, it says, as long as it's not cumulative, you have to disclose it. That means that if you have two patent applications, which you know about, and they basically say the same thing, they have the exact same subject matter, but there are different variations on it. In all reality, you only have to disclose one of them. Next slide, please.
Interject a comment, Mike.
Yeah.
We had a case, it goes back, I'm going to say 12, 15 years ago,
Right.
where we disclosed the publication of an application, which happened to have been our own the company's prior patent, okay? And then the examiner issued a notice that we were guilty of fraud on the patent office because instead of disclosing, because we disclosed only the published application, not the issued patent. It took some to do, but we eventually got the patent office to expunge that decision. But the point is that the examiner was initially claiming that we violated the duty because we identified in the duty to disclose the published application, but not the issued patent. Well, very weird, but
very weird, and I'm sorry you had that experience. It's definitely a new one that I've heard. One basic truth in U.S. patent prosecution is every examiner is different, and every examiner has the thing which they will enforce on you, whether you like it or not. So we do the best we can, and in situations like that, it would be a real immediate response, which I'm sure you gave, which was to try and start working the levers of the system to make sure that it's expunged, because, like you said, that type of thing it's not required by the duty and the rules, and clearly it wasn't properly done. So, okay, it happens. Moving on, what are the types of things which need to be disclosed? So look, you don't have to turn over every stone to look for material documents. It's if you know about it or if they're cited against you. And we'll talk about this a little bit more, and it really is the grayest area here. We're talking about what's material. And there are different approaches to this in IDS practice among US practitioners. There's broad disclosure, meaning you're going to list every single thing that you know about the application or about the invention or about the subject to the USPTO. Or there's maybe a little bit more narrow, a little bit more measured approach, which is things which are cited against you, things which come up in formal analyses which are done, and other things which your inventor might think are important. Well, we can talk about this later on, but there's definitely a range of approaches here. A question which often comes up is, is it necessary to disclose actual patent office work product? And what I mean by this is the examination report or the office action itself. And we do have colleagues which ask us to do this. And when we're asked to do this, we of course will file it. It's not necessary. The US, as I'm sure you're all have experienced, has different ways of approaching their interpretation of prior art and the way that the law deals with them than other countries. So the opinions of other jurisdictions, it's not really that relevant, I think, or material to patentability. Of course, the references which are cited by those office actions are most of the time necessary to cite. The other thing which is important to put before the patent office are the results of patentability searches. So if you've done a search and there are references which are considered to be material to patentability that come up in that search, they do need to be cited. If you get 300 hits on a topic and only 5 of them come up as being relatively important, those other 295 most likely do not need to be cited. Next slide, please. Okay, so the question at the top is what happens if an IDS is not filed? But let's start with, well, what happens when we do file the IDS? The documents cited in the IDS are reviewed and if properly cited and submitted, the examiner is going to acknowledge that they exist. Basically, it's the Patent Office's way of saying, yeah, we know about this, and either we're now going to incorporate what you've submitted to us into our rejection, or we're going to say, well, we know about this, but we don't think that the patentability of your claim is affected by the documents you've submitted. And this is all a lot of words that are not spoken, but it just goes under the heading of the reference is acknowledged. And acknowledged documents are printed on the cover of the patent, and that actually gives notice to the public, which says the USPTO saw these documents, it reviewed them, and it decided they are or are not important for patentability. So it gives the public notice. If the document is not acknowledged by an examiner, if it's not on that list, then it can be more easily used by a patent challenger. And this is where we get into the little bit of terror in the IDS requirement, because if you miss a document or you didn't cite a document properly, later on, if you have an accused infringer, the first thing that their attorney is going to do is look at what's cited on the cover of the patent. And if something's not there that the accused infringer knows about, you can be sure that it's going to be brought up by their counsel. And here's the other bit of terror, is that if a document is intentionally hidden from the USPTO, the patent can be invalidated. Now, there was the flavor of the weak counterclaim when I first started 15, 16 years ago in every US patent infringement suit there was inequitable conduct on the part of the patentee. And that was because the accused infringer said, well, there are these documents that you didn't submit in an IDS, and you did that intentionally. And because of that, it's inequitable conduct, and your patent should fall. The standard for asserting that type of thing or proving that type of thing has been solidified, I'd say, in years since, and those types of counterclaims are very difficult to prove because it requires the two prongs of both materiality and intention. As long as you keep proper records we keep proper records of whether or not a reference is being cited or not. Intention can be very difficult to prove in that sense. So, Jeremy, next slide, please. Okay, let's talk about the timing of all this. So, like I said, it gets a little bit more difficult over the lifespan of a patent application from filing to issue. When we first file the patent application, up until receipt of the first office action, by that in the US, that's the first substantive office action, not the restriction requirement. Up until receipt of the first office action, you can file basically anything without USPTO charge and without making any sort of certifying statement about that document. Later on, between the issue of the first office action and the final office action or allowance, you can, between the first office action, and the final office action, you can file any document by paying a fee if it's older than 3 months, or by a certification statement. And I'm going to take a step back here. There is a desire on the part of the USPTO for anything which is material to be submitted to the USPTO quickly. And the way that they incentivize that is by this rule, these certification statements. And so any document which is cited by a corresponding office within 3 months, or that the applicant or inventor finds out about within 3 months, we can certify this fact to the USPTO. And if we can make that certification, that is what we're talking about here. So when we say fee or certification statement, that's the issue. If you can make that certification statement, you don't need to pay a fee at this part of your patent application process. If you can't make it, then you pay the fee. After prosecution is closed, meaning after the issue of a final office action or after notice of allowance, you can still submit documents which you become aware of, as long as you pay the fee and can make that certification statement. So you can see this incentive to get things on record early. If you cannot make that certification statement at this time, you have to file a request for continued examination in order to get it on file and have it acknowledged by the examiner. All of this, of course, has to happen before the issue fee payment. If you become aware of something after the issue fee payment, Jeremy, next slide, please. Then things are even more difficult because you've paid the issue fee, your patent is on its way to issue, but you find out about this document. So what do? If the reference was identified or cited within the last 3 months, then what you can do is this kind of new pilot program with the USPTO called a Quick Path IDS. And ask for it by name. It's like a commercial. Ask for your Quick Path IDS by name. And what it allows you to do is petition to withdraw the patent from issue. And then you file a provisional RCE. And of course, your IDS. If the examiner does not reopen prosecution, meaning if the examiner does not think that any of the references cited on the IDS are material to patentability, it's their call, not ours, then they'll refund the RCE fee and then reissue the notice of allowance. That is only, the Quick Path IDS is only available within 3 months of a reference being identified. If you can't make that certification statement, then you have to petition to withdraw from issue and then file an RCE. The last thing, I'm not sure if it's on the next slide, but what happens if your patent's issued? And that's really the worst case scenario. Look, if your patent's issued and you find a document or a document is identified and it really becomes an issue, you think that it's really a challenge to claims which have issued, the recommendation there is you file a request for ex parte reexamination on the part of the applicant. And you get that document in front of the examiner and discuss it, and hopefully you can get the patent reissued. Next slide, please. So to the last slide here in this section is, well, what do we do here at JMB? So what we try and do is that we try and submit the IDS as nearly as soon as an application is filed, and we'll go through an example of this later on. At the same time, we're keeping track of all the corresponding applications in the family where they are across the world. And if a new office action comes in, we first see what's been cited. And if there's been something that was cited which was not cited or listed on the IDS, we docket 3 months from the date of the office action issue, and then submit the IDS within that time. After we receive the notice of allowance, there becomes a question of, well, how quickly do you pay the issue fee? And like I said, if the issue fee has already been paid, it can be a little bit of a challenge, to get that reference before the examiner. So if you think that your application is safe in other jurisdictions and you're not expecting to get anything new, don't worry about those. If, on the other hand, your application is a part of a big family in lots of different countries around the world, and you're still expecting office actions or examination reports in the near term, I'd say wait until you get those, until as late as you can to pay the issue fee, so that if anything does pop up along the way, you can file it pretty readily before the USPTO. Jeremy, I think that's my last slide for now.
There you go. Thank you, Mike. So we're now moving on to a sort of case study. Clearly, we're not going to be discussing actual cases, but we are going to be looking at, in practice, in general, what we're looking at is that there's going to be a priority application, which is not going to be in the US normally, a PCT application, and then national phase entry in a bunch of places. And so in this, so before I talk about what we do in the with Israel cases, or with Israel part of this, Mike is going to discuss, again, pretty briefly, now it shouldn't take more than a couple of minutes, everything that is said just now, but in the context of this actual filing. Assuming that I can, here we go. Just before we do that, this is very important. I mentioned before that pretty much anything that is prepared to be filed in the US in the form of an IDS, that is what is required in Israel. And in fact, this is, it's in this table here. And by the way, as I put in the chat, I will be sending a copy of this presentation, distributing it afterwards. May not be today, but in the next couple of days, it will get out, be sent to everyone. And what is particularly noteworthy are those yellow highlighted features on the left. That's a column which talks about a type of document. Every other type of document, you'll see that what we have the requirements in the US. In Israel, the requirements are either the same or less. And what I mean same or less is that it is less, where sometimes in the US, you need to file a complete document copy. And that's particularly if you're talking about a non-US patent publication. In Israel, all you need to do is to provide the application or patent number so that the examiner can go and fetch it himself. When we talk about non-material citations, there, in Israel, that's the only time in Israel where we file something, we definitely need to file it. Whereas in the States, there's a question. And again, Mike will circle back around to that subject a little bit later. So the case study, and Mike, you're on again.
Thanks, Jeremy. So here's to apply a little bit what we were reviewing a few minutes ago. So say you have a Japanese priority application, you have a PCT, which is filed based on that. And then we enter the national stage of the PCT in several jurisdictions. We have in Australia, China, in the EPO, and then also a US and an Israel case. And just say, for instance, we're handling both the US and the Israel case, and I'm going to go over what we would do typically for the US. And then Jeremy will discuss what happens in Israel and then how these interact. So when the US case gets filed, we'll typically file a first IDS along with that national stage entry. And that will include any references which are listed on the ISR in the PCT stage, and then any other references that we know about or that are brought to our attention. Here's a PTO fun fact. The ISR references are actually pulled by the USPTO over the course of when they process the application. However, even though the examiner is, of course, going to see them, they're not necessarily going to be listed on the cover of the patent. So we do need to submit them on an IDS, because if, again, I'm a litigator of an accused infringer and I see a reference that was listed on an ISR and was not cited on an IDS and is not acknowledged by an examiner, that's going to be my first go-to. Well, why not? And what import does it have? After that first IDS is filed, say you get a couple of search reports from the Chinese Patent Office and the European Patent Office. So we haven't gotten an office action yet, and so we just file them. File them, don't have to pay a fee, don't have to make any certification statements. And then we get our first office action, and examination begins. And then, as sometimes happens, you get another search report. So you get this other search report, and a couple of other search reports. Well, first, you've gotten one from the Chinese Patent Office here. Sorry, I'm mixing up my timeline a little bit. You've got this search report from the Chinese Patent Office after the filing of the second IDS. And then you get this other search report from the Australian Patent Office after issue of the non-final office action. If all of this is done within 3 months, you file your third IDS with your certification statement and no fee. Timing's a little bit funny here. So if, say, you file this IDS number 3 and it's 3 months, it's more than 3 months after the search report from the Chinese Patent Office, even though it's less than 3 months after the issue of the search report from the Australian Patent Office, you still do need to pay the fee because at least some of the documents listed on it are more than 3 months old. Moving on, you get a final office action. And then after that, there's another office action that might be issued. If there are new references cited, well, the question is, well, what do you do with them? Here, in reality, the best practice, the best thing to do is you cite them on an IDS as soon as possible, as long as it's within 3 months. Check that box on the form, make that certification statement, pay the fee, and get it on file. If things are fast, it's still better to do it before the notice of allowance or before you respond to the final office action. For example, every now and then you get a final and it's really not so scary. All it is a little bit of formalities that the examiner wants you to do, and you take care of that. It's still important to get those references in front of the examiner as soon as you can, just in case the examiner has some second thoughts and wants to mull something over or change their mind before issue of notice of allowance. And so that's that, preferably before the NOA there. And then the last, we have this absolutely the latest, if you can do it, is before the payment of the issue fee. Because like we said, after the payment of the issue fee, things get a little bit trickier, especially if the reference if the reference is older than 3 months, then you're kind of out of luck and you have to file an RCE, and kind of takes you back to the beginning of the cycle. The last thing here is, well, what happens if in that last office action one of those references the equivalent of an A reference? What if the examiner just throws something out saying, well, we've got this background information, and I think I should cite it, but it's not really figuring into my decision on patentability. It's certainly not a novelty destroying reference according to, say, Chinese patent law. Certainly not a inventive step destroying reference according to Chinese patent law, but I think it should be cited. So then there's a question. Normally if we were at the beginning of this, I would say don't think about it and probably just file it. Depending upon, we'll talk about this a little bit more, there are other considerations that come into play here. So it takes a little bit more thought, and we'll talk about this later. But for now, let's leave it at, if the reference is clearly non-material, then there's no obligation under the strict duty of disclosure to submit it get it on an IDS at this point. And as Jeremy will say in just a moment, that is one key difference between the US and Israel.
Thank you, Mike. Okay, so back to the beginning. Another focus is on Israel. So the first difference you see readily, the fact that the initial IDS, which was filed, which essentially is consisted of the ISR, when you file the US application, you're not required to file that in Israel at that point. And in fact, the duty of disclosure in Israel starts only at the time that you respond to what we call the Section 18 notice. This is the notice prior to examination, where there are a number of requirements under Section 18 of the law. I'm not going to go into all of them, but one of the things is that we then need to file essentially what is equivalent to all the IDSs that we have filed up till then. And that includes all non-material references. Okay, and as Mike said, and I'm saying now, that's one key difference. But in terms of the practice, if we are dealing with both of these cases, we simply take the IDSs, we will add any non-material references of which we have become aware, which you've told us about, and we will file those as well with our single response to the notice prior to examination. Okay, as we move further along, so now we have a situation where IDS number 3 has been filed in the US. So we have references, we have whether citations or general references. Normally they're going to be citations from corresponding applications. So we have these references that we know about. We should file those immediately. There is no penalty per se for not filing. But on the other hand, we want to make sure they get to the examiner before he actually starts substantive examination. And therefore, as you see in this situation here, we've got a non-final office action coming down the pike. Of course, we don't know what the timing is going to be. But as soon as we know about, and that's for that reason, as soon as we know about this additional IDS, these additional disclosure documents, we should get them on record without delay. Okay, so now, if, on the other hand, we did not know about them, and in the meantime, an office action issued, then at the very least, we file our IDS with our response. Again, it's the earliest opportunity. I see that if you're looking at the yellow cloud, there's a mistake there. I've identified IDS number 2 should be number 3, of course. Okay, now moving right along, we know that we're going to, let's assume that things go very quickly, and we get a notice prior to the notice of allowance. Okay, that notice is just for the uninitiated. That is a notice which says that examination has finished. It invites us to pay the issue fee, where the application will then be published, normally within a matter of weeks. it will be published for opposition for a 3-month period, after which, if no opposition is filed, the patent will be granted. Now, jumping the gun a little bit here, the duty of disclosure in Israel, I talked about when the duty of disclosure begins and finishes. Mike mentioned it with regard to the US. In Israel, it is up until allowance. It's up until that publication. Okay, now we all know very well, at least in Israel, we know very well that once examination has been finished, the examiner has said, I'm done here, and he issues the notice prior to the notice of allowance, inviting us to pay the issue fee, he will not pick up that case again. So we can file whatever we file, he will not look at it, but because we are not given the ability to make a judgment call here, Section 18 says very clearly what has to be filed and when it has to be filed. So then we must file, and in this case, we're talking about IDS number 4, okay, for additional references in the Chinese case in this example. We have to get those on record, and it doesn't make any difference whether or not the examiner will look at them. Okay, and the latest that we really want to be filing those, let's say that last IDS, is going to be with the payment of the issue fee. Okay, it is inadvisable. We theoretically can file another disclosure after that, but as I said, we have no control of when the issue fee is actually, when the publication is going to occur. It could be in a couple of weeks after we pay the issue fee. And so again, we want to make sure that no one at any time can come back to us and say that our conduct was inequitable and that we hid things from the patent office and by extension from the public. Now, so this is an interesting situation. Okay, we've had all the IDSs which have been filed when they've been filed. And then we get additional references, in this case from Australia. And let's say they are material references. Okay, so as I mentioned a moment ago, even after the issue fee has been paid, prior to publication, we must file an additional update with these additional disclosure documents. Okay, if we're talking about material references, also as I mentioned, material or not, the examiner will not look at them. However, our interest, of course, is to make sure that the patent that we get is going to be a good, strong patent. And if we know those references may be problematic, we want the examiner to look at them again. Now, we have an option to reopen examination, provided that we have not paid the issue fee. So what that means is that instead of paying the issue fee, we instead write to the examiner in response to the notice, asking to reopen examination based on the documents that we are now enclosing. Now, here's a bit of a problem, because the question is, have we been sitting on them, or did we learn about them just recently? And if the examiner feels that we did not update him in a timely fashion, he can say, nah, not going to happen, don't want to reopen the examination. And then we have two possibilities. One is we can decide to request a post-allowance, you can even have post-grant narrowing of the claims, which we feel will do the job, to exclude our claim from this new reference. And the other, in a way simpler but more expensive route to go, is to file a divisional application. In Israel, as we know, as opposed to the United States, there's no such thing as a continuation, but you can have a divisional application, and that may be the way to go. So now, I just mentioned material references. Now we're talking about non-material references. And as I said, if there's still time, we should disclose them. Again, it doesn't do anything for patentability, but it just shows we are fully in compliance with the law. But then we get back to the United States. And Mike is going to really hit this question over the head, almost with a sledgehammer. Does the fact that we have disclosed them in Israel, these non-material references, make a difference?
Okay, thanks, Jeremy. So look, we're talking about a very particular flavor of document here. I just want to be very clear about what we're talking about. First of all, if your inventor comes to you and says, yeah, there's all this background material, it's not really important, that's not what we're talking about. What we're talking about is a patent office somewhere in the world has come to you with an examination report and has labeled it, either has specifically labeled an A reference, which is in the jargon is strictly background material, or that the examiner says, yeah, there's just to know there are these other references out there, but they're not material to your claims as they're examining them. There is a question as well, what do we do about these documents? As you know, and as I mentioned before, the US Patent Office is going to relate to prior art much differently sometimes than other patent offices around the world. We all know that deeply based on the experience with US examiners. But at the same time, there's no obligation from the federal rules in the strict black letter of the law to disclose to the USPTO non-material documents. So what do you do? And this becomes something of a judgment call. If you feel in consultation with your clients or in consultation with the inventor that a document is not material, and you have that on the record, the question may arise at some point about whether or not or why you did or did not disclose a document. But as long as you have that on the record, the non-disclosure of that document, because there was a clear determination that it was non-material, is not going to harm the validity of your patent later on. I will stand on that hill. And you may throw things at me about it, but I will stand on that hill, and I feel very comfortable in making that statement. On the other hand, if there's any doubt, if there's any feeling that, well, a US examiner may look at this the other way, then we're already in the region of where maybe it's not clearly non-material, maybe it could be material. And in that case, you got to do what you need to do to get it on file. Like I said, there's no obligation to seek out references. There's no obligation to disclose to the USPTO purely technical, non-material background references. And that may be a judgment call that you as the professional need to make in consultation with your clients and the inventors. What you do need to do, and this is what we do ourselves, is if we do make that determination that a reference is either non-material or, I'm adding this in, duplicative of something else which has been cited beforehand, put it in your file, put it on the record, make sure that you have some sort of notice and some sort of paper trail, so that if the issue ever does come up, then you have that record. One thing that Jeremy actually said to me yesterday, which I think is a really another way to look at this, is if you don't want to think about this at all, think about the neighborhood you're in, so to speak. If you are in a highly competitive technology area, and you know that it doesn't really matter what you patent, it's going to be potentially infringed or maybe potentially attacked by some other third party, don't think about it, just put it on file. I know that goes against a little bit everything I've just been saying before, but sometimes a broad disclosure, like I said in the very beginning, broad versus narrow, broad disclosure is the best practice. Again, this is a little bit of a moving target, and you have to use your best judgment. But this is when we say in our letters, in our practice with our clients, if you have a doubt, if you have a question, please send the reference to us. Let's have a discussion about it and see what we need to do.
Okay, thank you, Mike. I'm going to stop the share here. Let's get back to everyone.
Thanks everyone for your attention.
Okay, so there are two things I would just say. That, as I mentioned before, that whether you want to learn about Israel or the US, or both, even if we're not handling both applications, clearly this is a situation where the US and Israel Council are clearly able to talk to each other about the issues, and particularly that last issue. I'm guessing most US attorneys would not be sensitive to. There is another point that I want to mention that I should stress, because this is a question that we get a lot, and that is, do we need to submit copies of office actions in Israel? And the answer is no. The only thing we need to submit are copies of references, lists of references attached or cited in those office actions. But with regard to what Mike defined as per the US, the work product of that patent office, it is totally unnecessary to submit. Okay, now there's one thing. I mentioned before that everyone can put all of their questions in the chat. I noticed, in fact, there was just one question asked by Sonia, and which I think Sonia, I'm going to ask you to ask the question, not me simply reading it. And I'd be very interested to hear. I have my perspective on the answer, but I'd be interested to hear if anyone else has their own perspective. And I'm sure that as many as we have people, we have perspectives. So Sonia, if you want to unmute yourself and ask the question.
The question is this: most companies in Israel, I think 80%, are now incorporated in the United States. Why would they file in Israel? It doesn't make any sense to me anymore. If you're thinking US or EU is your main market, why spend the money to file in Israel? I'm just a little confused why you'd want to do that. Unless if your product is going to be definitely used in Israel, then it makes sense. Does that make sense?
Question makes sense.
Great.
Yeah, Bruce, go ahead.
It's very simple, is that you may have employees who are working in your engineering department who will skip town and go to a competitor in Israel. And if you have an Israeli patent, it's much simpler to stop those people from using your technology. It's always recommended to get a patent in your own neighborhood, even though it may not be your prime commercial area for selling the products.
Something to add here as well. I have experience in the pharma field, and there's a small pharmaceutical company that you may have heard of called Teva. When you look at the history of Teva, I think that its big growth happened in the 80s, when it sort of transformed itself to a pretty small pharma company on the worldwide scale in the generic field. And I see other people here that have experience in Teva as well. So thanks for joining. But so we're talking about a pretty small pharmaceutical company to a company that at some point was the largest generic pharmaceutical manufacturer in the world. And a lot of this had to do, believe it or not, with the Arab embargo. There was a time in the 1970s when Arab countries were trying to put political pressure on Israel. It was around the 1970s, and basically said, to various governments, to various countries, if you trade with Israel, we're not going to do any trade with you. So certain countries had a choice of, are we gonna trade with this small little um, country with 2, 3, 4 million people, or are we going to trade with a lot of countries that are part of the Arab League, and thereby have a potentially bigger market? So the answer was kind of clear, and large pharmaceutical manufacturers, including Japanese manufacturers, just stopped filing patent applications in Israel. So Teva saw that as an opportunity. Okay, we have Israel as a manufacturing site. We can manufacture drugs here that can't be manufactured in other jurisdictions. And then we can basically get to the market earlier, potentially, in certain jurisdictions because we have that manufacturing capability in Israel. No one's going to stop us because people just, the small country, no one looked in our direction, and the coast is clear here. So I think that provides some insight. In other words, if we look at Israel as a potential manufacturing site, um, I think it's especially in the pharmaceutical world, it's pretty clear that you need to file in Israel.
Thank
I'll just
Uh,
I'll just add that I'm pretty sure there's one case where it was easier to stop selling in the US by halting manufacture in Israel. Meaning, so on point, it was easier to halt manufacture for the US market in Israel. Yeah.
Yeah, I think that's a good point. And I mean, if you're looking at litigation is costly everywhere. But if you have an option of litigating a patent outside of the U.S. and having the same effect as litigating it in the U.S., um, it's a clear decision business-wise that you're going to want to litigate it in Israel and stop the manufacturing, and taking into account that Israel is not only manufacturing to the U.S. market but also for other markets as well.
Okay, thank you, Cheryl, as well, for your contribution. We're going to wrap up in a second because we're almost at the top of the hour. With regard to the embargo, it's an IP-related story that I have. It's actually trademark, not patent, but it has a certain lesson in there, and besides which, it's a cute story. So one of the companies that stopped selling its product in Israel after the 73 Arab embargo was Pepsi Cola. And if anyone starts smiling, it means maybe you've heard the story. Anyway, so there was a very enterprising businessman from somewhere in the north of Israel that decided to go into the manufacture of a similar type of beverage, and he called it Pips Cola. And that was widely sold, in fact, primarily in areas with predominantly Arab population. Maybe they felt a little bit aggrieved. Why can't they get Pepsi Cola just because there's an Arab embargo? So there was this Pips Cola. Many years later, well, not that many actually, but long enough afterwards, Pepsi Cola decided that it wanted to re-enter the Israeli market. But in accordance, in line with its embargo, it had allowed its trademark registration to fall. And it found to its much to its dismay that Pips Cola had registered its trademark. Bottom line, due to I'm not sure whether they would necessarily actually had a problem, but due to their discomfort, with this registration, but even more so with this product on the market, they paid this enterprising gentleman from the north of Israel, I believe I heard at the time it was some of $300,000 just to go away. So anyway, that's sort of apropos, an interesting story to end up on. So this is it. We're at the end here. It is good to see everyone. It would be great to actually talk to everyone individually, but this is not the forum to do so. If anyone wants to contact us individually, I think you know how to do that. We'll be happy to talk to you. And certainly for those of our colleagues overseas who may be at Inter or Bio, Avram and I and another trademark colleague will be at Inter. Mike will be at Bio. And we look forward to seeing all of you again sometime in the not too distant future. Thank you very much.
Thanks
Thank
everyone
you.
for joining us.
Thank you.